Hey everybody, Matt Johnston here, back with another COVID-19 legal update. And this is about the Families First Coronavirus Response Act. So the FFCRA was passed early on in the pandemic response by Congress, and it provided for two kinds of leave. It provided for federal paid sick leave of up to 2 weeks or 80 hours, and it provided another 12 weeks of expanded FMLA leave, and these two leave provisions applied to all employers with 500 or fewer employees. So this covers all small businesses that are out there. Yesterday, a judge in New York City, a federal judge in New York City, handed down a decision in a lawsuit that had been brought by the state of New York against the Department of Labor. The lawsuit alleged, among other things, that the Department of Labor had exceeded its statutory authority in issuing some regulations. There were four main lines of attack, but the real one that matters is the attack and ruling in favor of the state of New York dealing with the various kinds of leave that are available. The Department of Labor had issued regulations that said that if an employer had determined for any reason that an employee did not have work available, so even if the employee was working from home, even if the employee was working remotely or part-time, if there was no work available, the Department of Labor said that that person was going to be ineligible to receive any FFCRA leave, either the paid sick leave or the expanded FMLA. The state of New York said that that was that exceeded the authority that the FFCRA gave, and argued that even employees who were on a furlough status would be eligible to receive that leave, including pay. So the question that the federal judge had to answer was, did the Department of Labor exceed its authority? And the federal judge said yes. So essentially, even furloughed employees would be eligible for FFCRA leave, including the paid sick leave, including the EFMLA. And by the way, the EFMLA includes 10 weeks of paid time off. Now that paid time off is at 2/3 of an employee's regular pay or capped at $200 per day, but that can still be a significant hit to businesses that are not operating, or businesses that are operating in a limited capacity. So while the ruling itself only affects a small part of New York State, there is going to be a question of whether or not the Department of Labor will revise its regulations. So the next step for this lawsuit is for the Department of Labor to decide whether or not to appeal to the Second Circuit Court of Appeals, U.S. Circuit Court of Appeals. And even if this Second Circuit Court of Appeals rules in favor of New York State, it still would not have a nationwide application unless the Department of Labor changed their policies. So I do think that at some point the Department of Labor is going to have to make a decision about whether or not to change their regulations. And in changing their regulations, here's the hard part. If you're a business that is operating or not operating at all, or you are a business that is operating in extremely limited capacity, whether that's 25% or 50% of your normal capacity, you may still be required to pay employees that you have furloughed. You may have to pay them the 2 weeks of paid sick leave under the FFCRA, or 12 weeks, of which 10 are paid, of the expanded FMLA. So it could become another financial hit. It could be a very expensive hit, particularly if you are not operating and you laid off a good chunk of your workforce. You may have to pay them, which of course may cause an interesting uptick in other side effects such as business closures or things of that nature. So if you are a business that is right now has furloughed workers, or you're operating at a much limited capacity, this is a good time to start thinking about how you're going to handle a change in the regulations dealing with the FFCRA. If you want to have a conversation, please don't hesitate to reach out to us. You can see our scheduling link down below in the show notes. And in the meantime, I hope everybody is staying safe out there. Wear a mask, and we will talk to you later. Bye-bye.